Can companies like Palantir legally collect and analyze massive amounts of personal data? Surprisingly, yes. But the reason has less to do with loopholes and more to do with how the law defines collection. Palantir doesn't actually go out and spy on people itself. Instead, it builds powerful software platforms that government agencies and private clients use to organize and analyze data they already have. Think of it as the digital glue connecting databases that were previously separate, like immigration records, tax data, or law enforcement reports. So how is that legal? Under U.S. law, most of these government databases were created through existing legal authority. For example, immigration forms collected by Homeland Security, or tax filings collected by the IRS. Once the government lawfully collects the data, companies like Palantir are legally allowed to process it on the government's behalf, as long as they follow privacy and security rules laid out in contracts and statutes. The Privacy Act of 1974 is the main federal law governing how agencies handle personal information. It requires notice, limits on sharing, and security measures. But it also allows routine use exceptions. That's how agencies can share data with other agencies or contractors like Palantir, as long as it's for an approved purpose. Critics argue this stretches the spirit of the law, since technology now allows much broader real-time data analysis than lawmakers originally imagined in the 1970s. But technically, as long as the underlying collection is lawful and proper safeguards are in place, the analytics are too. So yes, Palantir and similar firms operate legally, not because they bypass privacy law, but because the government invites them inside it. The controversy isn't whether it's legal, it's whether the laws themselves are keeping up with the technology.